right, very good. We've got the notice that we are live and we're ready to get started on this Zoom docket of the Kansas Court of Appeals. My name is Steve Hill and I get to be the presiding judge today. We have two cases for oral argument here via the Zoom software. It's my honor to be serving on this panel with David Bruns and with Kim Schroeder. And we're all three longtime members of the Court of Appeals and will no doubt want to ask you some questions about your case. I can tell you, counsel, that we have read your briefs and we've received a memorandum from our research staff concerning this case, which we have read as well. So since we only have 15 minutes per side, I would suggest that you get right after it. That's not much time, especially in a case where I think 24 issues have been raised. Counsel, I can tell you this. I don't know if this is your first Zoom argument or not, but because of the way things work, if we have a question, it's been our experience that one of us will raise a hand. So please watch out for that. And so, because there is some delay in the software, and give us a chance to ask you questions. And we'll also give you the chance to answer them in the same fashion. So try to signify or look for our signal for that. All right, we'll begin with Mr. Miller. You are here on behalf of the appellant, David Richard Sprague, and it's case number 121535. Is that correct?
That is correct, Your Honor.
And you are representing the appellant, and do you wish time for rebuttal?
3 minutes, Your Honor, please.
3 minutes, you've got it. And then for the state?
Jeffrey, Jeffrey, Your Honor.
And were you on the brief? You were not, were you?
I was not, Your Honor.
And are you the county attorney or?
Correct.
All right, very good. With that in mind, let's get started. Mr. Miller, proceed.
Thank you, Your Honor. And due to the number of issues, if it please the court, I would like to focus my attention today on 3 of those issues, and that's issue 14, issue number 4, and issue number 1 in that order. And of course would be available to answer any other questions regarding any of the other issues, but I wanted to focus on those 3.
And so it's clear you're submitting the other issues on the brief, is that correct?
That is correct.
That's fine. Because with all of these issues, there's no way you could have an effective oral argument in 15 minutes on all of those.
Correct.
All right, proceed then.
Thank you, Your Honor. Beginning with issue 14, we've raised the issue that Ms. Effenbeck was ineffective in essentially waiving the petitioner's right to testify and in failing to request another competency hearing. And so the confluence of this issue are 2 fundamental rights: a defendant's right to be tried while competent, and also one of the few decisions that a defendant and only a defendant can make with advice of counsel, and that is the right to testify. This event occurred on the last day of trial, and it's found, excuse me, in volume 19 of the Record on Appeal. During the discussion about Mr. Sprague's, whether he was going to testify or make the decision to testify, there was a fairly extended discussion. During that discussion, Mr. Sprague, on several occasions, stated, "I don't think I have the capacity, or I don't have the capacity to make this decision. And on a couple of occasions, he said, I think Julie, referring to Miss Effenbach, should be the one to make this decision. He just said, emotionally, I want to, but I just can't make the decision. I'm not capable of making it. And that was, and again, at another occasion, he said, I don't feel qualified to make that decision. So there was discussion back and forth. Miss Effenbach at one point said, how you're feeling today, it probably wouldn't be a good idea to put you on the stand. In addition, during the discussion, Miss Effenbach finally, towards the end of the discussion, said to Mr. Sprague words to the effect, do you trust me to make this decision for you? And Mr. Sprague said, yes, I do. And then the discussion thereafter, and again, the court, the prosecutor, Miss Effenbach, they were all asking questions of Mr. Sprague. He expressed confusion, certainly at times during this exchange. And eventually, towards the end, there were just statements to him saying, do you understand you have the right to testify? And he just said yes, and yes to that he didn't want to testify. So it's sort of just one word answer. And so I think you have to take in, obviously, the entire record, the circumstances around the entire record, and the circumstances about Mr. Sprague's mental health, which we've outlined throughout the brief. Dr. Hutchison was called to testify at the 1507 hearing, and she actually had conducted an evaluation of Mr. Sprague and had concluded, based upon her evaluation, that he suffered from a significant or severe delusional thought disorder. For instance, he expressed at the time to law enforcement and throughout the proceedings, and even clear up until the time Dr. Hutchison evaluated him, that he believed that his wife was either possessed by a demon or had actually become a demon. And when she attacked him in the barn, which is where this event occurred. He also expressed numerous times that his house was haunted by the ghost of his grandmother, that the ghost of the grandmother was forcing Candy, who was the victim in this case, his wife, to take pills. So there was certainly significant evidence of Mr. Sprague was suffering from a significant thought disorder, not only specifically at the time that this discussion was going on regarding his right to testify. And in fact, he had been on suicide watch. That was mentioned during this exchange. He was on suicide watch the night before, and during that discussion, he expressed the belief that Julie Effenbach was the one who had requested that he be put on suicide watch, which Dr. Hutchison, during her testimony at the 1507 hearing, indicated that was at least an indication, even at that time, that he was suffering under a delusion. I know the court is well aware of the standard for competency. The individual, the defendant, has to understand the nature and purpose of the proceedings against him or her, or where he or she is unable to make or assist in making the defense. And of course, as we know, that decision to testify is only the one that Mr. Sprague could make. And we submit here that the evidence, both from the trial transcript and the evidence that was presented at the 1507 hearing, especially through the testimony of Dr. Hutchison, was that he was not capable of making the decision at that time. At that point, Ms. Effenbach, we submit, had a duty under the Sixth Amendment to halt these proceedings. And in fact, it was actually suggested first by the prosecutor and then by the court, do we need to stop here? Do we need to take some time for you to talk to Mr. Sprague? And Ms. Effenbeck basically just said, no, we're just going to proceed forward. And I think it was during that exchange or closely around that exchange is when she turned to Davin or Mr. Sprague and said, do you trust me to make this decision? So she even had the opportunity to stop the proceedings and did not do so. We believe that's deficient performance under the Sixth Amendment. And then as far as prejudice is concerned, as we've outlined in our brief, Mr. Sprague was deprived of his right to make the decision on his own to testify. And in addition, we've also argued under the prejudice prong that this whole exchange that occurred where the prosecutor was essentially injecting herself as well, directly questioning Mr. Sprague, which I haven't practiced criminal law a long time, but even in my limited experience, I've never seen where a prosecutor is directly making comments and asking questions of the defendant in this regard about his right to testify. Ms. Effenbeck, in fact, when she actually read the transcript at the 1507, she was surprised. I don't know whether she hadn't remembered it or not, but she was surprised that she had allowed the prosecutor to inject herself into that proceeding. And so we have argued, at least under the prejudice prong, that for all of those reasons, Mr. Sprague is effectively denied his right to effective counsel completely at that point. So there's prejudice, we think, on a variety of levels here. As to issue number 4, it sort of flows into what I have discussed under the first issue. Issue 4 is ineffective assistance of Ms. Effenbeck in failing to investigate and present a mental health defense. And in that regard, Ms. Effenbeck, when she was questioned at the 1507 hearing, she basically said, at first, she said, I don't remember if I had a strategy or not due to the time period that had elapsed. And then, and as we've cited, Shumway v. State and other cases say, a loss of memory or a lack of memory cannot serve as a strategic basis under the Sixth Amendment. She later then said, but I think that I was considering it at some point. But she never conducted any sort of an investigation. She never put on any sort of a mental health defense, which is interesting because at the time or post-conviction, after the conviction, she had significant enough concerns about Mr. Sprague's mental capabilities that she got funding from bids to hire a psychologist or psychiatrist to do a mental health evaluation, at least for purposes of sentencing. And she was aware of some of the traumatic things that had happened during Mr. Sprague's childhood. So she was very well aware and had been aware. She testified that she had even concerns when Mr. Sprague was expressing these thoughts about demonic possession, that his wife was a demon, that his house was haunted, and so forth. But she never pursued that defense. Now, the district court below said that, well, she essentially relied upon the public defender's file, and the Salina public defender had represented Mr. Sprague before Ms. Effenbeck. They had him evaluated by Dr. and I don't know if I'm pronouncing this correctly, but I believe it's Ho, Dr. Ho. His evaluation is an exhibit, is part of the record on appeal. And he had found that his report really focused more on the self-defense part, I think, that Mr. Sprague didn't have a valid self-defense claim, although he didn't really elaborate a lot on the mental disease or defect part. Now, the district court said, well, Ms. Effenbeck didn't have to investigate on her own because she had Dr. Ho's report. And
Counsel, you're about out of time.
Okay. Anyway, we cited Robinson versus State to say that she still had a duty, especially given her understanding of Mr. Sprague's mental condition, she still had a constitutional duty to pursue that defense, and she could not have made a strategic decision not to pursue the defense without at least finding another expert. So we find that is deficient performance. The prejudice prong, the district court did not reach, and we submit Dr. Hutchison's testimony in support of our prejudice prong. I know I'm out of time, and I would ask the court to, for all the issues, we would ask that the court would reverse the decision below and grant relief so Mr. Sprague could have a new trial. Thank you.
Thank you, Counsel. Mr. Abel, let's see. You may begin.
Okay, please, the court. As the court's aware that the standard obviously is a two-prong test to be considered in these kind of cases, alleging ineffective assistance of counsel. As it relates to point number 14 or issue number 14 that was raised here today as the right of the defendant to testify as to whether or not he's given ineffective assistance of counsel. The state would argue that at that point in time, several things need to be looked at. It's easy to sit back and Monday morning quarterback that situation several years down the road. What we're failing to, what I would point out, I guess I would say, is we need to look at what was going on at that actual time in question. You have two attorneys and a judge, along with the defendant in chambers, reviewing and talking about his decision as to whether or not Mr. Sprague was wanting to testify. There was obviously some reluctance on the part of Mr. Sprague as to whether or not he was wanting to do that. The state would argue that's a common and probably a very practical consideration for any defendant when he's facing premeditated murder charges as to whether or not he wants to take the stand and testify. To sit here several years later, come back and say, well, maybe he didn't really want to and he was forced to. I think that's second guessing the judge who was in the chambers and the two attorneys who were there with them. Obviously, there was probably a great deal of deliberation in that regard. Was Miss Effenbeck, was her performance below the objective standard, a reasonableness at that point in time? No. She had a conversation. She met with Mr. Sprague several times by the testimony at the 1507 hearing. She was there prior at the jail the night before, and then several times meeting with him as to whether or not he wanted to testify. The fact of the matter is Mr. Sprague just didn't know if he wanted to or not because he wasn't sure if it'd be beneficial to him or if it would hurt himself. And he was just afraid to make that call. So that leads to the second prong of that is whether or not the prejudice, if there is any stemming from that, creates any real probability that the result in this case would be different. And obviously the state would argue, no, that's not the case, that the results would not be any different. Whether or not Mr. Sprague testified or not, again, we would argue is kind of irrelevant at this point in time. The evidence was already in that Candy Sprague had been hit on the head, was laying on the ground bleeding, struggling for life, when through Mr. Sprague's own admissions, he put a rope around her neck and strangled the life out of her. The other evidence that did come in, showed that Mr. Sprague then buried her body, well concealed her body in the floor of the garage, took her phone, traveled all around Kansas City area, making phone calls to throw the police or anyone maybe tracking Ms. Sprague's whereabouts to throw them off the scent that anything had happened to her. That evidence would still have come in. It did come in and does not negate whether or not Mr. Sprague would have testified to. As it relates to the second issue brought up today, issue number 4, whether or not there's grounds for to present a mental disease or defect defense, Again, I want to point out that at the onset of this case, uh, the attorney at the time, Paul Hickman, filed and was granted a competency evaluation, initial competency evaluation with Central Kansas Mental Health. That evaluation came back that Mr. Sprague was competent to stand trial. There was no further hearings requested at that point in time in that regard. Defense then did procure a report that was mentioned earlier by Dr. Howe or Hugh, however you pronounce that. And that report was prepared. That report was provided to Mr. Hickman, Ms. Sullivan, both at the public defender's office, and then to Ms. Effenbeck when she took over the case. At that point in time, through all three counsel on the 1507 hearing, they all testified that that report wasn't really going to be utilized because it didn't help Mr. Sprague's case. Mr. Sprague now wants to point out to Dr. Hutchison's report, again, a report that was conducted years after all this happened. The initial report by Dr. Hugh, that happened within 4 months of the time of the murder. Dr. Hutchison's report occurred 7 years after it. So the defense is asking or petitioner asking the court to make a finding here today that a report filed 7 years after the fact is more accurate than one that was done 4 months after the fact. And again, one that was discarded by all three counsel in the case at that point in time because it was not beneficial to Mr. Sprague's case. Again, I don't think the state would argue that it's not below a reasonable objective standard that not to use that report, that they didn't find it helpful. Again, three attorneys felt that way, that were all representing Mr. Sprague. Finally, I would just submit that, again, there are no errors in this case, certainly none that establish prejudice. Even if the court were to find more than a single error in all these issues, they are harmless beyond reasonable doubt based on the evidence in this case. Candy Sprague's body was found buried in Mr. Sprague's shop building. Mr. Sprague made multiple voluntary statements to the police that he did not know where his wife was before confessing to killing her. He made his confession after being advised of his Miranda rights on multiple occasions. The statements was that he strangled a prone, injured woman to put her out of her misery. Completely undercuts any valid claim of self-defense. He admitted to attempting to hide his crime by using Candy's phone in different locations in an attempt to convince her family that she was still alive. Quite simply, Your Honors, the evidence hidden, and it was overwhelming in this case. Although in the benefit of hindsight, subsequent counsel might have chosen different tactics or defensive strategies, Mr. Sprague received a fair trial and was represented by competent attorneys throughout. His conviction should stand. Thank you.
Thank you, counsel. Mr. Miller, you've got your 3 minutes.
Thank you, Your Honor. Just a few points I'd like to make. Dr. Hutchison, in making her conclusions at the time of the 1507, she relied upon Dr. Ho or Hugh's report and testing. She came to a different conclusion for the reasons that she stated on the record, but the idea that this was just done years later without any consideration of Dr. Ho's reports is just simply not accurate. She reviewed heavily and relied upon and looked upon many of the things Dr. Ho said in his report in reaching her own conclusions. And then second, I would like the court to take into note the May 3rd on the issue of competency. And on the issue on issue 14 was Ms. Effenbeck ineffective in failing to stop the proceedings and request a competency hearing? And of course, we want the court to look at all of the evidence, but I do want to point specifically to the May 3rd hearing It's in volume 13 and page 16. And there, the court during
What was your volume? What was your volume again?
it's volume 13 and page 16.
Thank you.
Yes.
Mr. Miller,
Yes.
in looking at the transcript at the in chambers conference, was the courts talking about taking a break for her to go visit with her client in private, or were they actually talking about a break for an competency evaluation in the middle of the trial? I took it as an opportunity for counsel and Mr. Sprague to go off by themselves and visit.
I think that is correct, Your Honor. I think that's what the record would show. I guess my point in making that is the opportunity at least was presented for Miss Effenbeck to at that point, speak to her client and determine whether she needed to halt the proceedings to have a competency evaluation, which the statute allows at any time, up to the taking of the verdict. I believe the statute says, if the court or defense counsel has a reason to believe or to doubt that their client is competent, they can stop the proceedings and ask for a competency hearing. And so I think that's our argument, is that opportunity at least was given and she did not take it.
Counsel, your time's expired. If you want to, I'll give you a minute to just sum up.
Sure. I've just asked the court, record 13, volume 16, where the court questioned whether Mr. Sprague had the ability to understand what was going on. Also, Mrs. Sullivan, who represented Mr. Sprague beforehand, she testified at the 1507 that if she would have continued representing him, she would have also asked for an additional evaluation of Mr. Sprague as well. And for all the reasons that we've stated in our brief, we would ask the court to reverse the decision below and grant relief to Mr. Sprague.
Thank you very much, counsel. We appreciate your argument, and we'll take the matter under advisement and issue our opinion in due course.